Hello and welcome to the Family Law audio program featuring Brazel lawyers in Gosford. My name's Lee Woodward, the CEO of Real Estate Academy, and the purpose of today's program is to gain some visibility on some very important topics that affect many people throughout their life. And today's topics, we're going to be looking at divorce, de facto relationships, property, children, court proceedings, costs and wills. And assisting us today on the legal side of all our information is Mr. Jeff Brazel. Jeff, welcome to the program.
Thank you very much, Lee.
Jeff, how long's your practice been running?
Our practice has been here in Gosford for 32 years. We started in March 1981.
So we've had 32 years to prepare for this moment and give some great advice, of which we're going through a scaffold of information today that you did as a seminar series. What brought you about to doing the seminar series for the community?
The law is full of mystery. People are often very afraid of going to see a lawyer to seek out advice, and we thought this was a way of presenting information to the public in a way that was in a friendly environment that would allow people to get information before they had to make a decision about what they might want to do.
And the law is changing all the time. You hear people giving advice on things that changed years ago. And there's the general consumer saying, is it 6 months with that? And I didn't know that. And you think, you should get some real advice here because we have a Chinese whispers effect going on to what really could have a significant impact on your decisions.
There are lots of bush lawyers around, and my advice to anyone would be to go and get proper advice about your own particular situation rather than relying on general advice from friends or relatives.
Well, Jeff, we appreciate you giving your time today because from our perspective at Real Estate Academy, we're obviously nationally involved with property and people making those decisions in the unfortunate situation of a divorce, a separation, or something that's going to impact on the asset, but also the family decisions. So when we have the opportunity to come together and speak with you, it's a great opportunity because I think many people need advice, but they're embarrassed to get the advice. Not wanting everyone to know your full and personal situation can be a dark and difficult time.
It certainly can, and that was the purpose of these sorts of information seminars, to provide information in a non-threatening atmosphere. People can then go away and make some informed decisions about what they might want to do, and then armed with that knowledge they can then seek out professional advice tailored to their own particular situation.
Well, let's get started with one of the larger topics of our whole program today, which is divorce. Where do you start in the counselling and legal side for someone, for them to better understand what's about to happen?
Well, Lee, since the introduction of the Family Law Act way back in 1975, there's no longer any fault associated with divorce. The grounds of divorce are essentially that the marriage has broken down irretrievably, and that's evidenced by the parties to a marriage being separated for a period of not less than 12 months. That separation can be a physical separation, but it can also be people being separate and apart under the one roof, and quite often economic circumstances of people will drive them to have to continue to live together, although the relationship has broken down. There's no time limit on divorce. People can live separate and apart for many, many years, and some people never even bother getting divorced. But divorce itself is a legal process whereby the marriage is terminated, the marriage is brought to an end. And as I mentioned earlier, the sole ground for divorce is an irretrievable breakdown of the marriage. In the old days, things like adultery and desertion are no longer relevant. It's all about that irretrievable breakdown of the marriage relationship evidenced by 12-month separation.
So two people can be separated under the same roof due to financial issues. How does that date in time start, and how do you activate the situation that, look, we're separated but we're still living together?
That's a very good question. Prior to the Family Law Act, you could actually get a decree of separation before you started to run the time for divorce. Nowadays, there's no such judicial decree of separation. All that people do is that they have to swear an affidavit, which is an oath where you promise to tell the truth, and you list the date that you've separated in that affidavit. Sometimes there might be a dispute between people as to the actual date of separation, and that can have an effect later on when they're talking about property settlement and property division, because the date of separation is often relevant to those sorts of issues. But essentially it's for the parties to decide for themselves when they've separated. If they're living separate and apart under the one roof, then they will require some additional evidence to satisfy the court that that's the case. Essentially, they have to show that they're no longer presenting to the world as a couple, and they'll normally require somebody from outside the relationship, friend, for example, to give an affidavit to court to say that, yes, I visited Mary and Joe Bloggs and they were living in separate bedrooms, they weren't going out together as a couple, they were having their meals separately, all of those sorts of things that you associate with people no longer living together as a couple.
It's true that you must be divorced before being remarried. That would seem logical, although some people do forget, and time goes on and it's a bit of an awkward thing at that moment. Does that happen often?
It does happen sometimes that people, as I mentioned earlier, there's no imperative need that people have to be divorced when they separate. So sometimes what happens is that people will separate from each other, they will form new relationships. It has been known that people in the new relationships decide that they want to get married and they might pick the date and do all of those sorts of things, and they've forgotten that they haven't started the process yet to formally divorce their previous partner. When you get a divorce, the court makes what used to be called a decree nisi. So the court says, yes, this marriage will be terminated, but there's a 1 month delay before that decree becomes absolute. I've had clients in the past where they had their marriage to their second partner planned in between that month, and so they've tried to seek for a reduction in that 1 month period between the decree being a decree nisi to becoming a decree absolute. And courts are pretty reluctant to do that. So the moral to that story is that if you're going to plan your second wedding, make sure you're divorced before you do that.
Why do people leave it so long and these loose ends? We know of people that have been separated for 10 years and have never actually got divorced. What's the disadvantage to not clearing up that documentation and position in your life?
The biggest disadvantage probably comes with property proceedings. These days, so far as children's issues are concerned, it doesn't matter whether you're divorced or not. Likewise with property, there is a 12-month limitation period from the time that you are divorced until you must commence property proceedings. However, as I mentioned earlier, the date of separation is the relevant date for working out property settlement issues. However, when a court comes to hear a property application, they look at the property as at the date of the court hearing. So if you separate from somebody and you wait 10 years before you decide to apply for divorce and then perhaps property orders, you may have accumulated other property, and the whole thing can become very messy if you leave it too long to decide to tie up all of those loose ends in relation to both divorce and property.
Let's say someone didn't do the appropriate paperwork. It's 10 years down the track, they've remarried, there's another property involved. That first party would have rights of claim.
They do. In fact, there's a couple of fairly high-profile cases involving lottery wins and inheritances. One particular case on the South Coast where a couple were married to each other. They had, I think, a small child. They didn't have much in the way of assets when they separated from each other. A few years later, the husband was lucky enough to win lotto, and he won a fairly substantial amount. They were never divorced from each other. The wife in that particular marriage made an application for property orders, and because she had the care of a child under 18 years of age, the court had no difficulty in awarding or making an award of property to her based on the money that the husband had won in the lottery.
Fascinating. Now, Jeff, this brings to light people don't do the paperwork and tie up the loose ends because of the emotion. They just don't want to face it. They don't want to go through it. They don't want to speak to the other party anymore. And having all this paperwork and lawyers involved really drives a lot of friction into the conversation. But leaving it as a loose end is such a dangerous thing for anyone moving forward. And even as a bare minimum, would it be a good tip that they keep diary notes or journal notes? Because as you span back in time, things get foggy.
It's very important to keep proper records about everything. Before people can apply for property orders, the court has in place what are called pre-application procedures, and that's all about disclosure. So you need to be in a position to disclose all of the assets that you have, from property to bank accounts to superannuation, shareholdings and the like. Obviously, if you've got all the records in place to be able to do that, it'll make things much easier for both you and your lawyer, rather than having to reconstruct some of these things that have occurred over the years.
When we talk about time and things getting foggy, a great tip for our listener is to pop in and have a chat with a family law solicitor. Because, Jeff, that is a date-related moment. You may not take things any further at this point, but gaining some visibility on what happens, when it happens, what you need to consider, and if things do move on in time a long way, at least then we can say on the 12th of February 2014, I visited Brazel Lawyers, I had this conversation. There's some sort of anchor in time there that is legal.
That's right. It's a record of things in a point of time, as well as getting some advice on what your options might be for the future. It is also going to concentrate your mind on what you need to do in the future, and there's a record of things that you may have discussed with your lawyer that may be important. I did have a case some years ago involving a client who came to see me in relation to a family law dispute. There were children's issues. Sometime later, he applied for divorce. He was unsure of the date of separation, and I had my notes in front of me that said, well, when you came and saw me last time, you instructed me that you separated on such and such a date, so we'll use that as the date of separation for your divorce application. And that, as I mentioned earlier, had implications for his property application as well.
Let's move on to our next topic, which is de facto relationships. And there is definitely a lot of fog and community advice around this one, which is definitely not up to date with the law. What do we need to know about de facto relationships?
Well, Lee, since 2009, de facto relationships have really been dealt with in the same way that marriages have been dealt with under the Family Law Act. Prior to 2009, de facto relationships were regulated by state laws. So there are 6 states throughout Australia, and each of the states had their own laws about the way that children from de facto relationships and property out of de facto relationships were dealt with. But since the 1st of March 2009, the states, or New South Wales in particular, referred its constitutional powers for de facto relationships to the Commonwealth. And now all issues arising out of de facto relationships are dealt with under the Family Law Act in the same manner as issues arising out of marriages are concerned.
Have the courts gone to measures to streamline everything now into one sector versus it was different law, people would handle different things?
Absolutely. When the state courts were dealing with de facto relationships, there were very different principles often applied to property in particular and also children's issues. And you often had judges who were not specialist judges in this area of the law making decisions. And so we had a situation where there was an inconsistency sometimes with some of the judicial decisions being made. But now everything is dealt with by either the family court, which deals with complex cases, what used to be known as the Federal Magistrates Court, but it's had a change of name at the end of last year. It's now called the Federal Circuit Court of Australia. It deals with the less complicated matters and the day-to-day run-of-the-mill property applications.
Give us an example of a complicated matter.
A complex matter may include relationships where, for example, there may have been domestic violence throughout the marriage. And in certain circumstances, it's usually a wife who's been on the receiving end of that sort of treatment. She might be entitled to a greater share of the matrimonial assets by way of compensation for the criminal assaults, for example, that may have been committed upon her during the course of the marriage.
Now, that's if it's marriage, but the same applies in a de facto situation.
Yes, it does. I'm using the term marriage loosely, but these days de facto relationships and marriage would be dealt with in exactly the same way.
What is the definition of a de facto relationship?
A de facto relationship involves 2 people living in a bona fide domestic relationship. For the court to have jurisdiction to deal with that relationship, one of 3 things has to apply. Either the parties have to have lived together for a period of not less than 2 years, or there has to have been a child of the relationship. So even though they might not be living together for 2 years yet, if there's a child of the relationship, that's a jurisdictional ground for the court. And the third ground is if one of the parties has made a substantial financial contribution to the assets of the relationship. So it's a very broad jurisdictional ground. As long as you come in with one of those 3 jurisdictional grounds, the court will have the jurisdiction to hear a matter involving a de facto relationship.
So let's play Mythbusters. It seems everyone in the community thinks if you've lived together for 6 months, that's called a de facto relationship. Is that true or false?
In terms of family law, it's false. Unless there's a child of the relationship or they've made substantial financial contributions to the acquisition of joint assets.
What's an example of a significant contribution?
A significant financial contribution might be evidenced, for example, if the couple has purchased a home together and they've made a contribution, an equal contribution towards the deposit. Well, it doesn't have to be equal, but they've made a substantial contribution towards the deposit, and then they've each signed up for the mortgage repayments.
So regardless if you're married or not, if you are deemed to be a de facto relationship, the family law courts handle the matter in the same way.
That's absolutely correct.
What about same-sex relationships?
That's a new principle, but essentially now same-sex relationships are also dealt with the same as de facto relationships and marriages. So the same issues around children and the same issues around property apply as to either marriages or de facto relationships.
Well, that brings us to our next topic. Regardless if you were married, a de facto, if you're now in dispute and there is a property involved, let's discuss what we need to know about property applications.
Well, Lee, first of all, there are a couple of time limitations in relation to applications for property. For a married couple, the limitation period does not start to run until they become divorced. So if they never get divorced, the time limit will never start to run. But if they are divorced, they must apply for property orders within 12 months of being divorced. If not, then they have to seek permission from the court to bring their application out of time, and it can't always be guaranteed that they would succeed in having the time limit extended. For de facto couples, the limitation period is 2 years after you've separated. In essence, it's 2 years separation for both marriages and de factos, but with marriages they have the added advantage that the time limit doesn't really start to run until they've been divorced for 12 months. For de facto couples, the time limit starts from the time that they separate from each other, and they have 2 years to make an application to the court.
The property application is a document that must be filled out. What's in that document? What information does our listener have to give some preparation to that they can actually activate that step?
Before anyone can file a property application in court, and a property application, you're quite right there, Lee, it's a written document, it's an application filed in court where you seek orders. So you might, for example, want an order that the house be sold and that 60% of the proceeds of sale be paid to you. Whatever it is that you want the court to do for you, you set out in that document. But before you get to that stage, there's a requirement under the family law legislation for people to comply with what are called pre-application procedures. Those pre-application procedures involve full disclosure by both parties of all of the assets that they have. So things like real estate, motor vehicles, boats, investment properties, shares, superannuation, all of those things need to be properly disclosed, and the parties have to make genuine efforts to try and come to their own agreement before they can commence proceedings. Part of the documentation that you file in court will be a document that certifies that you have made those disclosures to the other side and that you have been involved in genuine attempts to try and resolve the matter before proceeding to court.
What an interesting point, though. When we say property application, we're not just talking about bricks and mortar and land. Property is everything the couple owns, be it cars, motor vehicles, boats and so forth. A couple of questions here that are of interest to our listener. What if the total asset base is in debt versus profit? Splitting debts is sometimes a situation. I know in Queensland, the floods could hit and a property was purchased for $680 and is now worth $440. So there is a negative equity situation which will need to be dealt with and split that way. And suddenly people don't want the biggest share now. I don't want 60% anymore because we look the other way instead of in a profitable way. What happens in that situation?
Well, in that situation, you're right. Whereas the parties are entitled to the net assets, if they're in surplus, they're also obligated in relation to matrimonial debts that have been raised. So if in effect they're insolvent and their debts are more than their assets, then yes, the argument's going to be around what is their respective liability in relation to those debts.
So really what we're trying to get across here to the listener is this pre-application or this disclosure time is really the negotiation where the two parties have got to say, okay, what's the deal? because it seems to be this is the moment where things turn nasty. I did this, I did all these things, and the lawyers end up really nutting it out with each other to come to some sort of agreement so that can then be presented to the courts. It could take some preparation time to gather all that information, and especially today with the introduction of self-managed super funds. You know, they may have joint super, that super may have property. How complicated does it get at that level?
Well, look, it can become very complicated. You're quite right. The amount of time and effort that goes into finding out what all of the assets are, getting a complete history of the marriage and the financial relationship of the parties, looking at future needs, particularly if the wife, for example, has the ongoing care of children. Those things take quite a bit of time. And look, statistically, 90% of all matters settle without going to court. It's only about 10% of matters that actually do find their way to court. Solicitors actually play a very important role in garnering all of the information together, giving people an indication of a range of possible outcomes. I mean, lawyers can't say to a person that this is definitely what your result will be if you went to court. But what we do is we give people a range of possible outcomes, and with goodwill on both sides. Most lawyers are experienced enough and expert enough to be able to know from precedent cases, etc., what the likely outcome of a matter would be if it did go to court. And so the negotiations are really around those ranges between the lower range and the upper range, and hopefully people will meet somewhere in the middle. And as I mentioned, 9 times out of 10, that's actually what happens.
This is a great and interesting moment for our listener. It doesn't have to go to court. The idea is to get resolution, most effective way, and then the last resort is court. However, just for our listener who may be on the angry side, family law matters that do go to court and the court gives a ruling that this is the deal and you are offered a better deal than what we're even seeing, they can actually ask the other party to pay the costs of the person who's been most affected due to the anger versus the outcome.
That's exactly right. And just before I get onto that issue of costs, even for those matters that do go to court, the courts are so structured that there are a couple of steps along the way where they try and force people into situations where they negotiate. So there will be an initial directions hearing. When an application is filed in court, you're given a return date, you go to court. The registrar of the court will try and get people to discuss their positions and to come to some resolution. If that doesn't happen, there will be what's known as a conciliation conference down the track, which is very much like a structured settlement conference where the registrar of the court acts almost like a mediator to try and bring the parties together to make their own decision. But if all else fails and the matter doesn't settle and it goes to court, usually our practice in our firm would be at a point in time we would make what's known as an offer of compromise to the other side, which sets out what we say we want for our client, the orders that we want. And if when the matter goes to court and the judge ultimately makes a decision which closely approximates that offer that we've made, then the general rule that each party pays their own costs is disregarded and an application can be made for the party that was unreasonable in refusing that offer to actually pay the costs of the person who's won. So as I mentioned, in family law, unlike other court jurisdictions, the usual rule is that each party pay their own costs, but there are some incentives for people to settle matters, and one of those is that if you receive an offer of compromise, you have to act reasonably in considering that offer, and if it's rejected unreasonably and the other party gets roughly what the offer was, then you could find yourself on the wrong end of a costs order.
What happens, and I'm speaking from experience here, I've represented hundreds of people in the property matters in the sale of their property, and that's usually after you've done your part and the property's then eventually sold. However, in some of the early stages where we were appraising property, which is one of the steps we'll talk about that has to happen, I've had situations where one of the parties just shuts down, they won't read letters, they won't go to a lawyer. One person has a lawyer and you could be instructing all these things, but they just don't get involved and won't play or move forward. What happens there when there's a shutdown?
Well, it depends, I suppose, how far that person is going to take things. But if they won't engage in the pre-application procedures and genuine efforts to resolve a matter, That doesn't mean that you can't apply for court orders. So you would file your application and you would file a document to say that you've attempted reasonable efforts to conciliate and mediate the dispute unsuccessfully. You file your application, it's served on the other party, and if they still put their head in the sand and refuse to do anything, what will happen is that the court will end up hearing the application in the absence of that other party, and orders will be made without that other party having the opportunity to input their own circumstances and their own point of view to the court. So putting your head in the sand is not a solution.
For both sides of our listener right now, we don't know who's listening to which part for which reason, but if you're a person listening to this thinking, I'm not going to court, I'm not answering your letters, I'm not doing anything, there is some serious outcomes there that you may get nothing because you didn't engage, which is an interesting word, because this can't be avoided. And what is that sort of timeline before, and correct me if I'm wrong, Jeff, but the courts don't take favourably to non-engagement?
Lee, when a client comes in to see us in relation to a property matter, we get all the information that we can about assets of the marriage and their financial history. We would then write to their partner, setting out the brief history that we have received from our client and setting out the orders that we say that our client is seeking to obtain. We usually allow about 14 days for the other party to respond to that. If we don't hear from them within those 14 days, there's usually a follow-up letter would then go out. If we haven't heard anything from them within a month, we would then seek instructions from our own client about then commencing court proceedings. Now, from my experience, there are a lot of people who may ignore those initial letters from a solicitor, but once they're served with a court application, there's very few people ignore that. Once they're served with a court application, they have obligations under the ongoing pre-application procedures to make disclosure. If people do not disclose all of their assets, and sometimes people hide assets from their partner, if that comes out later on, they can be in all sorts of trouble. They can be charged with contempt of court, which can involve fines, even jail time and good behaviour bonds. So it's very serious stuff to fail to properly engage and to comply with the pre-application procedures and make a full disclosure of your assets.
How does the legal team, do you do searches to find out these assets, or if someone doesn't disclose and they've got a hidden bank account or they own a property in a different name or it's in a property trust, how's that ever investigated?
It's fairly easy to investigate property because that's a matter of public record. So far as other financial assets might be concerned, the best way to do that is usually by way of a subpoena. We would often subpoena banks, etc. And it's interesting, sometimes, for example, we've had situations where somebody has moved on, they've repartnered, they've purchased a property with that new partner. In their disclosure documents, they're saying that they've got virtually nothing. We subpoena the bank records, in particular the loan application, where they've got to set out all of their assets to found the application for the loan, and that's often a very fertile area to try and harvest information about what assets they might really have and what they might be hiding.
What would be like a checklist for this property disclosure for this application of property?
The rules of court require a number of things. For example, bank statements for the previous 12 months, the last 3 years' tax returns, real estate agent market appraisals for any property. In relation to cars and motorbikes, the value that you can download from the internet from redbook.com, for example. Details of shares and investments, interests in any business that either of the parties might be operating, recent superannuation statements, and really any documentation related to the value of all property, whether it's in joint names or single names. And often people think that because things are in their own single name, that it's not going to be regarded as matrimonial property. And again, that's wrong. There's a requirement that you disclose all property no matter whose name it might be in.
There's another myth buster, isn't it?
It is.
So, but that one's in my name, they can't touch it. That is not true.
That's not true.
Well, Jeff, the future definitely belongs to the prepared in this situation. We want everyone to have a better future. Nobody needs to hang around in these situations for years on end. If it is over, it's over. But these steps will get you to where you want to be. What is the 4-step process for property application?
Well, the 4-step process is really what the court considers when it is deciding what orders to make. solicitors, when they are getting instructions from clients, taking all of the details of their financial history, these are the things that we are having regard to when we're going to eventually give advice on what we think the outcome might be. So the four-step process that a court takes is, first of all, number one, to identify the assets. And as I mentioned just a moment ago, that includes all assets that are owned by either party, no matter whose name those assets might be in. And it includes things like inheritances and money that one party might have received by way of compensation if they've had an injury at work, workers' comp, for example. The second thing to look at is contributions that the parties have made. And that can be financial or non-financial contributions, and they can be direct and non-direct contributions. And we'll explain a little bit more about that in a moment. The third thing is what lawyers call maintenance factors or future needs. For example, a wife who has ongoing care of children under 18, she's going to need some additional assistance by way of additional property to assist her to care for those children. It's not uncommon, again, for wives to be the party that has given up a career path in order to support their husband in his career path. Those sorts of disadvantage in the employment market and ongoing care of children, they're maintenance factors that need to also be taken into account that might add to the share of the property that the wife might obtain. And the very last thing is what's called the just and equitable approach. And that's a bit difficult. That's where the court pays regard to those first three items, identifies the assets, looks at the contributions the parties have made to the acquisition and preservation of assets, looks to future maintenance factors. But if it's only a very, very small pool of assets, for example, the court might decide, well, it's just and equitable that the wife who's got 3 children to look after, that she gets the lot, and the husband doesn't get any because he's got a job and he can earn an income and he can re-establish himself. So that just and equitable approach is really the wild card in all of this, and it's the reason that really, if you can avoid going to court, you don't want to go to court because you really don't know what the judge is going to decide on that just and equitable issue.
That's very detailed information, and later in the program I'd like to discuss children as a separate topic, being such a critical part of these emotional times and proceedings that get us to this situation of what is fair and just and what's right by the children. There seems to be a lot of discussion over contribution. So, for example, you might have someone, male or female, who's a high income earner, and then one of the parties is at home contributing to bringing up children, running the family home. How's that viewed from a financial and non-financial contribution?
Well, the contribution, and it's usually wives, the contribution of a wife as a homemaker and a parent is just as important in the eyes of the law as direct financial contributions. Look, in a lot of marriages, the common garden variety marriage, what normally happens is that a couple will meet, they'll marry, they start off basically with nothing. They will jointly acquire assets during the course of the marriage. They'll decide to have a family. The wife will then give up her employment and be at home to look after the children and take care of the household. And the husband will go out to continue to earn money, and that money might pay for mortgage repayments and also the household expenses. But the contribution of the wife as a homemaker and a parent is just as important as the contribution of the husband in that direct financial sense. So from a contributions-based approach, the contribution of both parties will be considered to be equal. There might be some adjustments around future maintenance needs. So, for example, there's a rule of thumb that lawyers have that the care of a child under 18 adds another 5% to the equity pool. So if the couple have come together, they've started off with nothing, they've acquired these assets, it's regarded as joint contribution, so 50-50. They separate, the wife might have 3 children, 5% per child, gives her 65% of the net asset pool, and the husband 35%. The wife may also have given up a career, be disadvantaged in the labour market because of the fact that she's got the care of ongoing children. So that might be another 5% that she might be entitled to. So you start off with a 50-50 contribution-based assessment, and then when you look at future needs, it might end up being a 70-30 split between the husband and the wife.
What happens in second marriages when the children are from a previous partner?
That's a very good question, and the fact that a party to a marriage is taking care of stepchildren is a contribution that is going to be taken into account because they're not that person's children. So at law, they might have a moral obligation to care for those children, but they don't have a legal obligation to care for those children. So because they're making that additional contribution to care for those children and support them, that is a factor that a court will take into account.
And another issue around this same topic is quite often the homemaker doesn't have the economical power to engage the lawyers and pay those bills. And maybe that's, they've got like frozen assets in a way because they can't access money from working while looking after the family. What happens there?
Lee, depending on the circumstances, it is possible for a wife, for example, to make, coupled with the property application, even before then, to make an application for spousal maintenance, to make sure that she's got the income necessary to support the household. And if the husband is in a position to do so, then orders can be made that the husband pay a lump sum on an interim basis, even to cover the wife's legal costs.
Now, we've discussed the contributions of the homemaker. What about the renovator?
Yes, Lee, the direct non-financial contributions that are made by a party to a marriage that might be making improvements, alterations and additions to property that has the effect of increasing the value of that property can be regarded as a plus on the ledger of that particular party. So things like building retaining walls, maintaining property, building alterations, new rooms, etc. All of those things can be taken into account, and they might add to the entitlement of the party that's done those things.
There seems to be a ledger in this part of the program, and we might take an example. Let's say a couple's come together and one of the parties was 90% the funding of the property, and then within 2 years those people split. Is that still a 50-50 split in the contributions as the court or the lawyers would look at it?
No, as we mentioned earlier, the court goes through a 4-step process. So the first step is identifying the assets. The second step is looking at the contribution that the parties have made either to the acquisition or then preservation of assets. So in the example you've just mentioned, if that party had 90% of what was required to purchase their property, then that 90% contribution is going to go on his side of the ledger and the other 10% perhaps to the other party. If they split within a very short period of time, then really the person who made that 90% contribution is going to get most of that back. That benefit of that contribution, though, will dissipate over time. So for a lengthy marriage, say 20 or 30 years, contribution may only be worth a few percentage points at the end of a 30-year relationship compared to getting it all back if they were to split after only, say, 2 years.
A sad fact of the divorce space is how quick and young some people are getting divorced. That's definitely changed over time. What happens in this particular situation where we may have a lovely young couple come together, they couldn't afford their deposit, so let's say the parents of the wife have contributed $100,000 to get them set up. 2 years later, they're now splitting. Is that contribution counted?
Yes, it is. As I mentioned earlier, the court looks at what were the contributions made by each of the parties to the acquisition of assets. So if the wife has received money from her parents, that's going to come in on her side of the ledger so far as the contribution is concerned. Some of the issues around gifts by parents, however, concern whether or not that was a gift or a loan. If it was a gift, then yes, it's a contribution on the wife's side of the ledger in this example, but over time, the benefit of that gift will dissipate. If it's a loan, then whenever they separate, whether it's after 2 years, 10 years or 15 years, that loan still has to be repaid, the full amount of it. We find often that in these situations, after lengthier relationships break down, that people try and argue that the money that was received from the parent was a loan and not a gift, but unless it's been properly documented as a loan, then it's more likely to be regarded as a gift. And sometimes I get to advise parents who might be considering advancing money to their child and their daughter-in-law or son-in-law. I would advise them that if they are expecting that should the relationship break down, they want the full $100,000 paid back to them, that really it should be properly documented as a loan and not just given to their child. Otherwise, it may result in problems down the track.
Let's look at a checklist for maintenance factors. What do we have to bring our attention to?
This is not an all-inclusive checklist, but things such as, for example, the length of the marriage, the age of the parties, health issues. So if one party, for example, is in bad health and unable to work, then they might be entitled to a greater share. the earning capacity of the parties and disparity of incomes. I've really already mentioned that. Often it's the wife, for example, who may have given up a career path and supported a husband in his career path. So that might be a factor that might entitle the wife to more of a percentage of the pool of assets. Financial resources, and financial resources can include future inheritances. It might include personal injury compensation. That's not regarded as property for the purpose of being divided by the court, but a court can certainly take that into account. So if somebody's had a major accident and they've got several $100,000 in compensation, that's a financial resource that the court's going to say that they've got the benefit of, and therefore they might give more of the percentage of present-day assets to the other party. The ongoing care of children is a big one. And as I mentioned earlier, a rule of thumb that lawyers have, and look, it's not a precise thing, but essentially 5% for children under 10 years of age, and also a fairly nebulous thing, but nonetheless an important one, is a reasonable standard of living. So if parties are used to a particular standard of living, if the children have gone to private schools and those sorts of things, then the court's going to take that into account as well.
Well, this brings us on to our next serious topic, and that is of children. Jeff, what do we need to know here and give consideration to?
Well, Lee, the very first thing that people should bear in mind is that the court is going to regard the best interests of the child as the paramount consideration in determining issues around where the child might live and who the child might spend time with. Just a word on that. A lot of people are probably unfamiliar with these terms. People in general parlance talk about custody and access or contact, and also about guardianship. Those terms are no longer used in family law, and we talk instead about who a child might live with instead of custody, who a child might spend time with instead of access or contact. And there are also other terms such as who a child might communicate with, and issues around parental responsibility, which is the old concept, I suppose, of guardianship.
Why was the removal of the word custody?
Well, it was really introduced at a time to diffuse many of the conflict situations that happen with children's issues, and custody can connote an aspect of possession of children, so they wanted to remove that. So instead of having custody now, it's who a child is going to live with.
The children part of any divorce is very, very sad, and for a lot of people, they don't get divorced because they feel it's because of the children and will stick together. And it's a known fact that bringing children up in a loveless marriage is worse than what we're talking about here. And I think in many cases, there's been children grow up saying, I wish they just got divorced instead of arguing all the time. From a legal sense, at what age does a child have the right to contribute to where they want to live without being manipulated by someone's thinking around where they should live?
Well, it used to be the situation that the court would not regard the interests or the wishes of a child until they were 12 years of age. That really is now no longer the case. The court will consider the interests of a child of any age. However, obviously the younger the child or the more immature a child is, the less weight a court will attach to those wishes being expressed by the child.
And how are those wishes extracted? Is it through counselling? What happens there?
Lee, the information is going to be extracted normally through a family consultant. What will happen is that the court will order that the family, so that's the mother, the father and the child, attend on a family consultant who is usually a trained psychologist, and that family consultant will prepare a report for the court, and in that report they will set out the wishes of the child as they've been expressed, and they'll also make some comments on the parenting skills of both of the parties. And that's often a very important component of the report because that's going to have impact on what the court might ultimately decide. In circumstances where there are allegations of child abuse, in addition to the child's wishes being expressed through the child consultant's report, the court can also order that the child be separately represented by a solicitor. And in those circumstances, the children's representative is obligated to produce to the court all information relevant to the interests of that child. You have to understand that under our court system, it's an adversarial system in which parties decide sometimes what evidence they will use and what evidence they won't use. Generally, they won't use things that are to their disadvantage. The idea of an independent children's representative is that those sorts of situations are going to be avoided, and even if there is information that parents might not want the court to know about, the children's rep is going to make sure the court does know about it, and hopefully also the family consultant will also refer to it in their report.
There has been situations, though, where one of the parents have sent the child off to a psychologist in order to get leveraged information that they wish to use in court. Jeff, this is not on.
No, it's not. I mean, there's a world of difference between a child going to see a child psychologist for genuine therapeutic reasons and a parent who sends a child off to a child psychologist for the purpose of obtaining a report merely for court proceedings. There is actually a rule in the court rules that prohibits that from happening, and it may actually amount to a contempt of court for a parent to send a child off to a child psychologist for the limited purpose of obtaining a report that is going to give them, or seek to give them, some advantage in the children's proceedings in court.
Hopefully not, but what if there is a concern of one of the parties that there has been some abuse? They're not allowed to go to the child psychologist. What should they do here?
Well, it's not necessarily that they can't go to the child psychologist. If it's genuine therapeutic treatment that they're after, that's fine. But if there is an allegation, say, of sexual abuse, really what that parent needs to do is don't waste any time, report it to the police. The police will then also consult with docs, and both the police and docs will have an investigation of the allegation. They may or may not decide to take any further action, depending on what evidence is available for them to corroborate and prove that allegation. But if a person is going to raise an allegation of sexual abuse in family court proceedings and they haven't gone to the police and they haven't gone to docs, then a court may take the view that this allegation is being raised simply for the purpose of trying to gain some advantage in the court proceedings rather than being a real genuine concern that the parent might have.
And again, this is one of those date-related moments, and hence you should report it straight away because time moves on and it becomes foggy again of when that incident happened.
That's right. There's also issues around credibility. If a person becomes aware of, for example, a sexual assault on a child and they don't report it, and then a year or two later when they're in court they suddenly raise these allegations, it just looks as though the allegation was raised to give them some advantage in those court proceedings rather than being a genuine concern. And really, if you have a genuine concern about your child, then you should be taking the appropriate steps to alert the authorities.
Let's move on to this topic of parental responsibility and clear up what's thought to be the case around shared care. What happens here?
Well, Lee, there's now a presumption that each parent is entitled to shared responsibility. As I mentioned earlier, a lot of the terms that people would recognise, such as guardianship and custody and contact, are no longer used. Parental responsibility is really a similar concept to what people understood before as guardianship. The right to have input into the major decisions in a child's life, such as education, religious training, consents to medical procedures and those sorts of things. So you start off on the basis that the parties are entitled to shared parental responsibility, and unless there's allegations of abuse, most likely that will be granted by the court. The issue of shared care, however, is quite a different kettle of fish. Shared care basically means that the child lives equally with both parents. And although there's a presumption to that effect, as I also mentioned earlier, about 90% of cases settle. So if the parents are getting on with each other and they can come to their own agreement about shared care, then that's all well and good. But for those matters that are going to court, where the parents are really not getting on, a court's very unlikely to order shared care in those circumstances.
What about if one of the parties wish to move away from the other person, be it an hour, 2 hour, a different state? What's involved there?
Well, look, that's, again, a very good question. They're called, lawyers call those things relocation cases. If a parent is seeking to remove a child interstate, for example, or to some other region away from where the child has grown up, there's a whole range of things that need to be looked at. The court needs to look at the effect that that's going to have the child in relation to the severing of other extended family relationships, the fact that the parent with whom the child is spending time, or the old contact arrangements, might be lessened. So, for example, instead of seeing the husband every fortnight and half the school holidays, it might now just be half the school holidays, and that might have an adverse impact on the child. There's also issues around the support that often the mother might have. So There was one case in particular a few years ago involving a mother who was living, I think, in Queensland and had to and wanted to relocate with her new partner down to Melbourne. The children had been raised in Queensland, the husband was in Queensland, but all the wife's supports, her extended family, were all in Victoria. On balance, the court considered that it was better for the wife to have supports around her so that she could properly care for the child rather than refuse her permission to relocate the children down to Victoria. These are very complex issues. They're not, in a situation like this, it's not very easy to give you any sort of black and white outcomes. They're very complicated issues.
What if a situation happens where, and we see it in the press all the time, the child was picked up for a normal visit and then they up and go in the middle of the night?
The law is pretty clear on that, Lee, that the court will issue a warrant for the child to be taken into custody and returned to the parent with whom the child was living, and can also issue a warrant for the arrest of the parent who has removed the child. You're not allowed just to pick up a child and go, and in fact now I think there are some criminal charges that can be laid against a parent for kidnapping their own child. That wasn't always the case, but that now I think is an avenue that's open to the police as well.
If we just summarise the object of the Act of the Family Laws, what is it we're trying to achieve?
Well, the objects of the Family Law Act, so far as children are concerned, essentially, as I mentioned earlier, the best interests of the child are paramount. The court is going to look to make orders that will enable meaningful involvement of both parents in a child's life. Thirdly, to protect children from physical or psychological abuse. Next, to protect them from exposure to abuse and neglect. To allow proper parenting so that the child can achieve its full potential, and also for parents to meet their responsibilities of care, welfare and development of the child.
Jeff, the purpose of this audio, other than provide clean information, is that people will understand the process, what you can and can't do, and come to a resolution between themselves and their appropriate lawyers so that it doesn't go to court. That is really a good outcome from someone listening to this particular audio, instead of pushing the boundaries but thinking I can do this, you're on old information and you've just hurt a lot of people. However, if that can't be resolved, what are the court proceedings process?
First of all, the parties have to go through the pre-action procedures and make full disclosure. So assuming that's been done and assuming they still haven't then been able to reach agreement, an application is then filed by one of the parties, who's called the applicant, in which that person seeks orders that they want the court to make. That application, when filed in court, is given a return date, usually 6 to 8 weeks in advance. A return date is just the date that the matter will be mentioned in court. During that time, the application then gets served on the other party, who's called a respondent. A respondent has to file a document called a response, which, if you like, is an answer to the application, in which they, that is the respondent, sets out the orders that they might want the court to make. Once that has been filed, there will then be what's called a case conference. So on that return date, the parties will both turn up at court. The registrar of the court will mention the matter and will try and elicit from the solicitors for the parties what the case is all about, whether there might be agreement on some things but disagreement on other things, and then we'll try to see whether the parties can go out and have some discussions to see whether they can reach agreement on those things that they can't agree on. If that doesn't happen, then the matter will be adjourned for a period of time, which again is normally 6 to 8 weeks, for what's known as a conciliation conference. A conciliation conference is in effect a structured mediation conference. The registrar of the court acts as a mediator. The parties are both present at court, as are their solicitors. The idea is that the parties appear in front of the registrar in the registrar's chambers, so it's not in open court, it's actually in the registrar's office. Both parties will sort of state their position as to why they feel that they're entitled to what they're entitled to. The registrar would usually make some comments around what he thinks a court might do if the facts as outlined by the parties are accepted. And then the parties usually go outside and there might then be some discussions around offers of settlement. One of the things that the registrar will do at a conciliation conference is impress on people that the costs that they will incur from this point will increase exponentially unless they can reach a settlement. If people are hanging out for $10,000 more than what they think the other side is prepared to offer them, and they're going to spend $30,000 or $40,000 to get $10,000, well, that's just totally not financially viable to do. So the registrar will impress that on the parties. The solicitors will do their best to try and negotiate and reach some common ground. If the parties can agree, then the registrar will make orders then and there on the spot, and that's the end of the matter. And a lot of matters do settle at conciliation conferences. If the matter can't settle, the matter will be adjourned again for what's known as a pre-trial conference, usually in about 6 months after the conciliation conference. At the pre-trial conference, the registrar will go through the things that the parties want to produce in evidence, so they might need to talk about preparing and filing and serving valuations, issuing subpoenas and those sorts of things. The matter will be allocated a hearing date. Directions will be given about the filing of affidavits, so each side, each party sets out their case in a document which is called an affidavit, which just sets out the evidence to substantiate the orders that you're asking the court to make on your behalf. Each party files their affidavits, other evidence is filed, and then the matter will be adjourned for hearing. Now, hearing dates, depending on how long the matter might run, could be 6 months to 12 months away. It just depends. The whole cycle from the time that you file your application until you get your day in court for a defended hearing can be 18 months to 2 years, depending on a number of factors. So it's not something that happens overnight, and that again in and of itself is often an incentive for people to settle those matters. Apart from the costs issue, you want to wrap this up and put it behind you rather than have it hanging over your head for another 18 months to 2 years. At the defended hearing, the parties will get it in the witness box. They will be cross-examined on their affidavit. Other witnesses may or may not be called. Then eventually the judge will make a decision and hand down a judgment. As I mentioned at one stage when we were talking about the four-step procedure and the just and equitable component, that's a bit of a wild card. It's not uncommon for a judge to make a decision, in fact, that neither party is happy with, and that's all the more reason why people should give serious consideration to settling their matter well before a defended hearing. So at least if they didn't get exactly what they wanted out of property orders, it's been a compromise that reached and they've agreed to, and something that they can live with.
A very interesting point for our listeners is the courts are very busy, and there is thousands and thousands of these cases, and the judge sees and hears every single type of story, and although that person feels they've got a unique case, the judges don't take kindly to people wasting court time.
No, they don't. I suppose but there's always two sides to a story, and some people just want their day in court. As we've mentioned throughout the program today, solicitors, before proceedings are even started, will do their very best to get all the information together and to give people advice on what the possible outcomes might be. There's at least two occasions in the court process itself, the initial case conference and the conciliation conference, for the registrar to try and bring people together to reach agreement. If a case is completely unmeritorious, then yes, you're just silly to go on to court. But sometimes people have entrenched positions, and that's really the very worst thing that you can have. The art of settlement is all about compromise. And if you can compromise and walk away with a deal that you can live with, save yourself probably many tens of thousands of dollars in legal costs and probably a year of your time that you'll never get back, I think you're much better off to settle.
I couldn't agree more. You're better to settle, move on with your life, enjoy that next chapter of your life. Divorce is not a great thing, but it happens to a lot of people, but a lot of people move on. What things should our listeners consider at this part of the program?
Consider participating in mediation to try and reach your own agreement. Then once you've reached agreement, consider entering into what are known as consent orders or a parenting plan or even a binding financial agreement. And lastly, negotiating good faith. And that's just very important. I can't stress that enough, that really, obviously, a breakdown of a marriage is a very emotive time. There's often lots of bitterness generated by the breakdown of that relationship. And so it's probably easy for me, sitting where I do, to say to people, negotiate in good faith, but you're going to save yourself a lot of grief, a lot of money, and a lot of time if you do negotiate in good faith and you're prepared to compromise.
Our final topic and question is in the area of wills. What do we need to consider here?
Well, first of all, if you're separating from somebody and you have already made a will where you are leaving your entire estate to them, for example, you might consider changing your will and perhaps leaving your estate to your children. If, however, you don't do that and you become divorced, or you are divorced, you should need to know that divorce does not revoke a will. What divorce does, though, it nullifies a gift to your divorced partner. So what I mean by that, if you have a will, for example, that says I leave all of my estate to my spouse, but if my spouse has died before me, then to my children, a divorce acts as though the spouse has died, for example. So the gift to the spouse will fail and the estate will pass directly to the children. Another thing to consider, particularly if you're going to repartner with somebody, is that marriage actually does revoke a will entirely. So you've separated from your spouse and you've considered, well, I need to make a new will to gift my estate to my children, and then you repartner and you decide to marry that new partner, that marriage will revoke that will that you've made. So instead of your estate going to your children, your new spouse then has certain succession rights in relation to your estate. So these are all things that you really should get advice about.
There's a very famous saying in real estate of where there's a will, there's a relative. It's amazing who comes out of the woodwork. People haven't attended to that paperwork again. And that's interesting you just mentioned that you may have had a will, but if you're remarrying, that can revoke, it does revoke that will. What does the new parties do in order to make sure everything goes to the correct place?
Well, they really need to see a solicitor to do a proper will, not, for example, to get a newsagent will and do it themselves, because there are issues around challenging wills that relate to blended families in particular. Because the previous will is revoked, if they were to die without having made a new will, they're said to have died intestate, that is, as though they have no will, and their new spouse will be entitled to a greater share of their estate, and their children from their first marriage might get less than what the person originally intended.
Well, as we can hear from this entire program, there is so much information you need to know. But for our listener, you don't need to be an expert on every point we're saying, but you do need expert advice. Jeff, you've contributed amazing time today. You've got a whole team of people that work in all parts of the law. What other parts of the law does your practice cover?
We're a general practice. We have a number of solicitors that specialise in particular areas. Family law is an area all on its own. Personal injury and employment law. We have my partner Peter Moore deals with that area, and he has two solicitors that support him in that area. In addition, we do conveyancing, we do leases, we do wills and estates, probate, challenging wills, commercial litigation, business law. We do all of those things, and we have lawyers that specialise just in those particular areas.
Well, your information is on our disc, but for the person driving along, what is the phone number should they need to contact you?
432476.